Right, my friends, I just pressed the Let's Go Live button, which means we've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, we got to make sure the tubes are connecting themselves. And we are having some tube problems today. We are not the only people with tube problems. Apparently, Rumble is having an attack or something going on. Our locals also has an attack. I don't know what it is. It could be China. It could be Russia. It could be Putin. Who knows what's happening? I was thinking it could be Viva, actually. It could be Viva. You know, I don't know what's going on down there at Rumble HQ in Florida or something like that. But, you know, he gets into some shenanigans out there with alligators and stuff like that. So somebody better check the server room. I don't know if Viva brought in a crocodile or something. But it looks like our tubes are connected. We also have Rumble. We're attempting to stream over there. Our locals friends, we're on the YouTubes. We're also on the X. It looks like we're mostly situated. That's tremendous. That means we can go ahead and get started. And so let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. And my name is Robert Govea, and today I'm a criminal defense attorney. And today I'm excited to get here. You can see we're talking about Jack Smith. And man, he has filed some serious motions today. We've got him going to the United States Supreme Court, and we are going to go through it in detail. Man, this is a good one. He is a little bit panicky. I think I can feel it in his bones. Molly and Jay Brett and everybody over there in his office, they're feeling the January 6th trial date slip through their fingers. We know it was scheduled to happen the day before Super Tuesday on March 4th, and we know that is a little bit askew now because Donald Trump is appealing a bunch of stuff. And so Jack Smith, we wake up on a Monday morning, boom, he's taken the case over to the Supreme Court. And so we're going to go in there and see what his arguments are. And he's saying, we got to go quickly. And why does he have to go so quickly? Why can't we just wait? Why can't we just kind of go through the normal routine here? Well, it's because of Super Tuesday. So we'll see what Jack Smith's up to. We'll see what Jack Smith's #1 fan says. His name is Andrew Weismann. He's over on MSNBC all the time. You know, Jack Smith's #1 type of guy. And so we'll see what he says about it. He says it's a smart move. I think he's panicking, which he is, obviously. We'll read the motion or we'll read the filing and we'll see. That'll be in the first segment. It's a nice filing, 60-something pages. And so we'll see what is inside. Then we'll jump over and see what Jack Smith is doing in Chutkan's courtroom, because he simultaneously to asking for a ruling from the Supreme Court, and it's on the issue of presidential immunity, he's also saying to Judge Chutkan, please keep the trial on as scheduled. Please do not move the date. We say Trump has asked the courts to postpone things or to stay the trial date, but Jack Smith is asking for that not to happen. And so he submitted this into Judge Chutkan's courtroom, and he also submitted this to the D.C. Circuit Court of Appeals simultaneously, saying, Judge, please don't move the trial date, and D.C. Court of Appeals, please don't move the trial date. And so he got 3 different filings that he's like, we have to keep this thing on track because they do not want it to move. And we have been watching, waiting for this, because we're going to see what Judge Chutkan does, and she might just have this whole thing ripped out from under her and taken away from her. We've also got a clip of Mitt Romney, who I think is voting for Joe Biden now, which is strange for a so-called Republican who was almost the president. Oh my gosh, what a disaster. Okay, so he's now saying there's no one to restrain Trump, and he's out there, advocating openly against Trump and in favor of the other side. And so we'll see what he had to say about this and more. And then lastly, we are going to jump over to the Chutkan gag order, and Trump and his campaign are declaring victory on that because the Court of Appeals came back down on this. And we got some technical stuff we're going through today. We've got the presidential immunity, we've got the trial date, and now we've got the gag order that we're going to have to dig into. And that is an interesting one because it's kind of split. In fact, Trump has been gagged. We know this out of Engoron's courtroom. We've also seen this out of the D.C. courtroom, but Trump appealed the D.C. circuit to the D.C. circuit, and we just got a ruling back on that where the judge is basically splitting that. Then we're going to see what Mr. Mustache Man has to say about this. We know him. John Bolton was inside Jen Psaki on MSNBC, and he was saying that Trump and his tactics are even worse than Nixon, which, whatever that means. And then this guy is saying, Trump could actually start shooting people in his cabinet, or like the vice president could just shoot the president one day and then pardon himself. It's wild, man. They're going into absolute bizarro land. It's a little bit crazy. We'll see if we can keep it together as we go through some of this madness. But as you can see, my friends, we've got a lot to get to today. We are excited that you are here and with us. We've got 3 segments to attend to. We've got Jack Smith, and we've got a lot of stuff here. Some reading, some Supreme Court petitions, some objections. It's good stuff. This morning, we had a great stream with our membos. We talked about all the day's affairs. We talked about some of the weekend's affairs. There was some good stuff that we chatted about, and we're working on building another little project over there that we'll be sharing soon. But we're having some fun over there discussing some of that as well. Today, before we get into the meat and potatoes on the show, we have to pause and say thank you to our friends over at PIA for sponsoring the show, and because they're just a pretty dang great company with great VPN services. Here is our sponsor. It's important to stay protected on the internet, my friends, and Private Internet Access will help you do that. Private Internet Access is a VPN service that creates an encrypted tunnel for you when you browse the web so that people on the same network as you can't snoop in and see what you're doing. And that's awesome. But what I also love about a VPN is that it allows you to change your IP address to one of over 90 countries around the world. This lets you bypass geographic restrictions on certain websites like Netflix that will often limit movies or TV shows like one of my favorites, The Office, and they do that based on your region, meaning that when you change your region, you get access to additional content you might not otherwise see. PIA also gets you around website geo restrictions. For example, Canadians now can't access Facebook News and Google News due to the controversial BC-18 bill, but with PIA, they can. And what I like most about Private Internet Access is that they are the world's most transparent VPN provider. With over 30 million downloads and a no logs policy means they never record or store user data. All this has been verified by a third-party audit from Deloitte and successfully defended in court in litigation. And now, Private Internet Access allows you to protect all your devices with just one subscription so you can protect your whole household in one go. Super simple. So let's get you a VPN from Private Internet Access. Go to www.piavpn.com/Robert and you'll get 83% off and 4 months free when you sign up for a 2-year plan. Be sure to use my link for a major discount on this initial offer, and my friends, we'll see you at piavpn.com/Robert. All right, so check them out. Private Internet Access, good stuff over there. And thanks for supporting the people who support our show here by getting your VPN from them. We also want to remind you about our website and where we'll be going over maybe for our after party today. We're trying to figure out what our technology situation looks like. But robertgovea.com, if you like any of the PDFs that we go through here on the show, you can get them at robertgovea.com. We also have our members only forum, watchingthewatchers.locals.com, and we'd love to see you become a member and join us for all the fun stuff that we do over there. All right, and so without any further ado, let's get right into it because we've got some serious heavy lifting today. We've got SCOTUS, man. Ooh, this is exciting. You know how much we love SCOTUS. Jack Smith, special counsel prosecuting Trump, is a little bit nervous. You can feel the panic in his bones as he submits his petition to the Supreme Court. Why is he going to the Supreme Court right now, you might wonder? Because he's already got an appeal that's on appeal at the lower level court, but he's trying to leapfrog them. He's trying to jump over the Court of Appeals because he is in a hurry. They really want to prosecute Trump. We know that the trial on the January 6th case is already scheduled for March 4th, the day before Super Tuesday on March 5th, and they want to keep that trial date because that's going to be when they can convict Trump. And they've got a limited time to do that. They need to be able to come out after that, which might be a 6-week trial, and say Trump has been convicted so that they can use that in the election. And if they postpone it, man, if they have to bump this thing, they're not going to want to bump it later in on the year, closer to the election. So they might have to go into 2025. And that means they lose everything they're working for. So they are filing quickly and asking the Supreme Court, please, please, please respond, even though it's not really supposed to be there. And we'll see what the Supreme Court says about it. We'll go through the filing. Then we'll see how MSNBC is talking about why this is a smart move and why I think this is not a smart move, why I think this is really them being boxed in, trying to get something done before the clock runs out. This is the filing. Jack Smith taking it to the Supreme Court of the United States. And this is the Super Bowl, my friends. This is where we want to be. We've been waiting for this. We've been waiting for Trump to get us here, but Jack Smith is taking us here right away. And the issue here is about presidential immunity. And if Trump is successful here, the charges are going to go away, like gone. And so depending on how this goes, it could be the end of the case, or it could be Trump continues to be prosecuted. But what's curious is Jack is going quickly. Now, as a quick side note, I thought Jack Smith had all these issues settled. I don't know why he's appealing this. I thought that he knew that presidential immunity was not something that Trump could legitimately claim, and that this was all settled. This was just an ordinary case. No one's above the law. They kept screaming at us. Remember that? No one's above the law. No one's above the law. Now he's asking the Supreme Court, excuse me, hey, Supreme Court up there, is Trump above the law? I think he might be. Derp, idiots. That's why you should have figured this out, or maybe not charge him in the first place. But now we're here, and Jack Smith is a little bit nervous. You see, the United States of America is the petitioner out of SCOTUS versus Donald Trump on petition for a writ of certiorari before judgment. See that? Before judgment. They're currently in the D.C. Circuit Court of Appeals on this issue that Trump took it to. And now they're saying, we got to go faster. All right. If we can't get this done, then Trump might have an opportunity to postpone the trial date. And that's really what we don't want. But as we go through this, let's ask ourselves, what is the urgency here? Okay. What does Jack Smith fear if this is not settled in the ordinary course of business? Okay, many other trials take a long time, especially when they involve what they claim to be is the most sophisticated and, extensive investigation in Justice Department history, which is like laughable, by the way, because what if they prosecuted about 1,200 people, which is a joke. It's like a Super Bowl weekend or something like that. Okay, produces way more crimes than that. So it's basically insane. But these people are now at the Supreme Court, and they're going to be asking for clarification on this, and it's going to be dispositive. And we've been waiting for this. We can't wait to see what SCOTUS does. But what if SCOTUS doesn't do anything? What if SCOTUS tells Jack Smith, it's not ready yet. Go back through the Court of Appeals, and then we'll see you later. That means that everything gets stayed. Trial's probably going to get postponed. So we've got a lot of different permutations that we could unpack here. Here is the question that Jack Smith is asking of the Supreme Court, which is wild because I thought this was already figured out, because no one's above the law. Here's the question: is and whether a former president, whether he is absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. Man, those are two very nice, very juicy questions that we are very excited to unpack. And we've already gone through several of these issues. Okay, one is Trump is immune literally just by virtue of the fact that he is the president executing the laws, right? So there's just immunity that you get. For example, when you are a police officer, right? You're executing the laws. You arrest somebody, they get injured, they sue you, they say you shouldn't have arrested me so hard, and then you claim qualified immunity. Hey, I'm immune from that lawsuit because I was doing my job, it wasn't excessive force, blah, 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 all the crap they say. So that is the framework, right? The president, by virtue of the fact that he is executing the laws, in this case, Trump is legitimately arguing that the election was rigged and he is the executor of the country at that moment on January 6th, and he's got a duty to make sure that the elections are not rigged. And if he's got the opinion and the take, you may disagree with it, that the election was rigged, he's got an obligation to make that known and to go and say, hey, Mike Pence, there's some problems here. And our opinion on the election here and why he was justified to call foul. So that's point number one. But then point number two, which is a separate, it's a related issue, because either one of these, if the answer is yes, gone, case is gone. Is Trump absolutely immune? SCOTUS comes out, let's say 6-3. Yeah, he is. Boom, case is over. They lose. Now think about that also, by the way. Okay, this would be a very good out. I know, at this pace it's going to take 2 months to get through this document, but we'll pick it up the pace here. But think about that. Now, what if Jack Smith and these people know that this case has been botched from the beginning, that it should have never been brought, They were hoping that the prosecutions would cause Americans to rally against Trump, and they failed, right? They've actually made him a martyr. And so now they want to say, uh-oh, what we've kind of bitten off more than we can chew here. What if they can pitch this on SCOTUS? They can just blame it back over to SCOTUS. Say, oh, we tried to prosecute an insurrectionist, but SCOTUS came back out and said Trump's immune from prosecution, right? Then they make the Supreme Court the boogeyman, the bad guy. Then they say, see, this is why you got to rally back over to our side and support us in packing the court, and Joe Biden needs to win. Otherwise, the Supreme Court, in cahoots with Trump, are going to seize power of American democracy, whatever. You know the story. So you can see how this can ping pong both ways, right? The court would take it away from them. And this is the reason why I get nervous about the court, is because the court doesn't like to do that, right? The court doesn't really like to step on the toes of the executive branch. We saw that when John Roberts led us through the Obamacare debacle. We were all sitting here like, there's no way this is going to pass. It's constitutionally insane. And then Roberts came out and he's like, aha, we're going to call it a tax. You go, what? Where'd that come from, John? But they did it. And so we're asking ourselves the same question, right? Is the judiciary going to step on the toes of the executive? Are they going to leave some discretion to them? Are they going to do something crafty and fancy and say like, well, Trump was at his speech at the Capitol was outside of the presidency, but some of the other things were inside the presidency, right? You see how this can get spliced many ways. But what if Jack Smith, knowing that this case is going to be botched, not in the courts necessarily by the jurors, right? Trump will be absolutely convicted if the trial goes. And if it's given to a jury, right? No doubt. It's DC. But the law is on his side because they're the ones who shattered all the precedent and who are trying to criminalize speech, and then who are shattering due process and even discovery in this prosecution. So great questions. The surprising thing is that Jack Smith is asking this, right? These were questions that I thought Trump was going to bring up, but he is leading it because they are panicked. They need to get these answered immediately. So those are the consequences that I foresee. Now let's dive into it. We fast forward through the materials, and here is the petition. Bum, bum, bum. They say right here on petition, before the judgment on appeal from the DC Court of Appeals. They say, the special counsel, Jack Smith, and his deranged thugs over there are hereby submitting this on behalf of our useless government and respectfully petitioning for a writ of certiorari before judgment, before the lower court has even had a chance to opine on this, which is unusual, saying of the United States Court of Appeals up to you. Now, the opinion and order of the district court is not yet reported, but you can look it up if you want to. They say the judgment of Chutkan was entered, and then the jurisdiction of this court is invoked as follows. They say, now, your honors, at the Supreme Court, this is Jack Smith and his team writing, saying, all right, Supremes, this case presents a fundamental question at the heart of our democracy. Whether a former president is absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. And we've talked about this, right? Trump was impeached in the House of Representatives, but not convicted in the Senate. This is the second time absolutely for the January 6th case, right? That's the subject of the second impeachment, which mirrors this same charge. So if Trump was essentially acquitted, this is double jeopardy charging him again in the criminal court if the Constitution requires a conviction in the Senate before you can go down this road. Saying the district court, Jack Smith writes, the district court Chutkan rejected Trump's claims, correctly recognizing that former presidents named Trump are not above the law, and they're accountable for their violations of federal criminal law while in office. Now, Trump and his appeal of the ruling, he appealed the ruling, rejecting claims of his immunity, and the trial is scheduled to begin. Now, what's curious about this? Here, look at this. They say Trump's appeal of the ruling, rejecting his immunity and his other related claims, however, suspends the trial of the charges against him. Oh, no. That sounds like Jack Smith is acknowledging that trial is suspended. Uh-oh. Man, they're going to be so mad over there. They are mad about that. They have been trying so hard to make this thing rigged so that it happens on the day before Super Tuesday. But Trump, just by virtue of appealing it, Jack says, it's suspended. So then he says, it is of imperative public importance that respondents' claims of immunity be resolved by this court, the Supreme Court, and that Trump's trial proceed as promptly as possible if his claim of immunity is rejected. Now, I really hope that they explain why this is so necessary for us. Is it for the country? I mean, the country needs to know the outcome of this case before we can vote in November. Like, why can't you just wait until after the fact, Jack? Is it because of the election? Like, I know it's because of the election. I'm willing to admit that. Are you? Let's see. Respondents' claims, Trump's claims, he says, are profoundly mistaken, as Judge Chutkan already held. If anybody, puts any faith in that one. But only this court, Supreme Court, can definitively resolve Trump's questions. And so this court should grant this case before judgment, before it's even really supposed to be here, so that it can provide the expeditious resolution that this case warrants, just as you've done before. They say, all right, Supreme Court, let me give you some background here. They say Trump served as president, as we know, January 2017 to 2021, pretty good years. The indictment alleges that Trump engaged in systematic and a deliberate effort to overturn the election results of 2020 and blah, blah, blah. Now, on August 1st, we know, August 1st, just think about how short this case is, by the way. Trial in March. What? A federal, for 13 million pages of documents and all the January 6th stuff? They're still releasing video footage. So a federal grand jury, they say in August, charged Trump with the various counts. Count 1 charges conspiracy to defraud the United States and alleges that he, seeking to re-elect himself, conspired, among others, to overturn the legitimate results of the election, blah, blah, blah. Leveraged DOJ state officials, we know the charges, and then attempted to obstruct the Capitol. Now, the district court scheduled trial to begin on March 4th, 2024, coming up the day before Super Tuesday, and they have already set out notices to jurors that we've covered here. But they are asking prospective jurors to also complete their questionnaires on February 9th, right? And that's like right around the corner. We're going to be there any minute. And all of this is in the lead up to March 4th. And so Donald Trump then, after all of this started, they're like, we're basically trials scheduled already. Like, we already picked out the curtains for it. Says and then Trump moved to dismiss the indictment on the grounds that he enjoys absolute immunity. Yeah, because he was executing the duties of America by not having our elections rigged, saying that he is immune from criminal persecution and prosecution for anything that's taken in the outer perimeter of his official duties. He also argued, you can't prosecute me twice. Double jeopardy prohibits that. And the Senate already gave me my trial on this, and I was acquitted. So you can't do it again. Now, Jack Smith and his deranged thugs there, they said that Trump has no absolute immunity from federal criminal prosecution. They said even if such immunity existed, it would be narrower than the outer perimeter test, okay? So, like, you can actually prosecute him for the things that he did, saying that the presidential immunity is different from civil liability, saying that even if that standard applied, this is Jack Smith, the indictment should not be dismissed because it's not in the outer perimeter. It's absolutely criminal, and it's also outside of the double jeopardy argument because they say that the Constitution doesn't matter, as usual. But the district court denied, this is Judge Chutkan, denied Trump's claims, both of them, the double jeopardy claim and the immunity claim, which are two separate and distinct entities. And the court concluded that the Constitution's text and structure and history support the conclusion. And we read through this opinion from the judge. I think it was the one where she said there's no historical text that supports Trump's claim. And then we scrolled up literally to the page before that where she cited Alexander Hamilton, who said exactly what we interpret it to be. So strange behavior, but anyways, it's her courtroom, so I guess she can do whatever she wants. History support the conclusion, she says, that Trump may be subject to investigation, indictment, prosecution, and conviction for any criminal acts undertaken while in office. Now, although the Constitution's text does not address presidential immunity, which you would just infer then, why does everybody else get governmental immunity except the president? The court observed that silence did not reflect an understanding that Trump possessed immunity. Instead, in opposite, the court explained that the constitutional provision that Trump invoked, the impeachment judgment clause, cut against his immunity argument. She said that the Constitution says that he should be prosecuted. She said that the first part of the clause limits the penalties of impeachment to removal and disqualification from office, and that the second part then says that, quote, the party convicted may then later face criminal prosecution, but that any further punishment may not come from the legislature. So she basically says it goes down two different tracks. And you can basically follow both of them. And only Congress can remove you and disqualify you, but only the other systems can criminally prosecute you. And so that's how we distinguish it, which is what we have said is that you have to go through, it's like an indictment process, or it's like a safety valve. You have to be indicted in Congress. You have to be convicted in Congress, in the political realm, in the jurisdiction of the political world, before you can be removed out of there and then prosecuted in the non-political world. And the reason for that is so that we have a separation between the two, so you don't have partisan prosecutor hacks like Tishy and Fannie and Jack Smith doing what they're doing. You got to go through Congress first, lest you can have these democracy people, trying to undermine it, attack it. So Jack Smith continues. Now, the district court, Judge Chutkan, said that there were several features of the impeachment judgment clause that undercut Trump's claims. First, she changed the word or interpreted the word nevertheless. She said that it doesn't bear on anything about whether they're subject to criminal prosecution. And she also said materials like those from Alexander Hamilton did not reflect the view that there was widespread consensus about the nature of that phrase, which, Alexander Hamilton was a pretty important figure back at the time. Now, third, she said that Trump's interpretation of the impeachment judgment clause relied on a negative implication that a president who is not convicted in impeachment cannot face criminal prosecution. And that reflected neither logic nor common sense. Now, well, not for his presidential conduct. That's what we're talking about. Okay, if the president goes and gets a DUI or something like that, right? It's a separate concept. Like, he's being prosecuted for his presidential conduct. Now, finally, they say respondents' interpretation would produce that there would be an anomaly that a former president would be immune if he committed a crime that was not covered. And so she read the rules and said, this could lead to an insane conclusion, and therefore we can't hold the rules work that way. Now, summarizing, they say that the district court also found nothing in the history to justify absolute immunity, and the court discerned no evidence that the founders understood the Constitution to give that immunity. And here in sum, they say Chutkan concluded exactly the way we want, and so we think that you should find similarly. So here is what they're asking for from the Supreme Court. Telling us, a cornerstone of our constitutional order that these people upended is this stupid phrase that they cannot get enough of. I think they probably have it written on their mirrors in the morning. Jack Smith says this every morning. No one's above the law, Jack. No one's above the law. They say no person is above the law, which is such a stupid phrase because the president literally is. I mean, I don't know how many times I can say it. I'm like a broken record here. So, like literally, somebody gets convicted of a crime through the regular order. They say, you're guilty. You did something very bad. Jury of your peers convicts you. The president like this goes like this. Watch this. Pardoned. Done. Gone. Doesn't count. Literally above that law. You're gone. Sorry. Doesn't matter. Right? And there's debate about whether the president can do it himself. So it literally is not that. Right? And if you don't want to use that example, you can also use the opinion clause example, which I think also says that he is above the law. The commander in chief, right? the laws say all these things. He just says, I'm doing this, right? He is the root of the Constitution. So it's a real stupid thing for them to say, but they keep saying it, but whatever. Now they say and like they're literally asking, excuse me in this request, is Trump above the law? Like they're asking that in this very filing, and then they use this stupid sentence. Asking, does Trump have presidential immunity making him above the law in our hack partisan prosecution? And then they say, no person's above the law. Okay. Now, it's not really a cornerstone then if you have to ask about it, is it? So the force of that principle is at its zenith, whereas here, a grand jury that nobody cares about out of Washington, D.C., has accused a former president of committing federal crimes. This is a hack grand jury out of D.C. The reason why we don't allow that to happen is so that it goes through Congress. Because if it's going to be politicized, we want to make sure Congress can vet it first. And they did. And guess what? He wasn't convicted. Jack. So they say to subvert the peaceful transfer of power to his lawfully elected successor, which we're debating that now. Yeah, a lot of people are. Saying that nothing could be more vital to our democracy than that a president who abuses the electoral system by trying to make sure it's fair is to remain in office and held accountable for his criminal conduct. But Trump has asserted that the Constitution accords him absolute immunity from prosecution. And the Constitution's text, structure, and history do not support that novel claim. Well, then why are you asking about it? The court has accorded, and why are you asking about it, Jack? Okay, Trump can make that claim, but you have some doubts, don't you? That's why you're asking. So the court has accorded civil immunity to the president in the case of Nixon versus Fitzgerald, but they held that the view that a sitting president cannot be indicted while in office. But those principles can't be extended to Trump. The separation of powers nor his acquittal in impeachment lifts him above the reach of federal criminal law. And like other citizens, he is accountable for criminal conduct. And again, right, like I said, like if Trump ran out and got a DUI today, yeah, like he doesn't have presidential immunity from that. Hello. But that's not what we're talking about. He was doing conduct that was within the presidency, which is executing federal elections, and he had an opinion about it that he's entitled to, and I think he's been vindicated on. So, all right, so this is overbroad. Nobody's saying that he can go out and do criminal things and then just claim presidential immunity like a get-out-of-jail-free card. It's ridiculous. So they say, all right, Jack Smith continues. The district court presiding over this case, this is Chutkan, all right? So every time they say that, just insert Chutkan in there, okay? It makes it feel a lot less, powerful. Judge Chutkan, okay. Now, she rejected Trump's arguments, okay? Great, that's why he's appealing them to the Court of Appeals. And his notice of appeal, however, oh man, they are so mad about this. Trump's notice of appeal, however, suspends trial proceedings. Oh, man, they're so mad about that. And they're referencing Trump's case, which is the case that we covered last time in their filing. Bummer. They're acknowledging that. Oh, man. So that's why they're begging the Supreme Court, can you please hurry, please? We need you to go because we need this trial. And they say Trump has moved for a stay of all proceedings in the district court while his appeal is pending, as is his right. Now, here's Jack Smith crying, it is of paramount public importance for us that Trump's claims of immunity be resolved as expeditiously as possible. And if Trump is not immune, that he receive a fair and speedy trial on these charges. Now, by the way, speedy trial is in the interest of the defendant, okay, as much as it is for the government, right? So Jack Smith is on team government here, that we need to get this done so that the public knows that he's an insurrectionist and a convicted felon before the election, before they go vote on Super Tuesday, because they got to get him out of here. And then once he is convicted, as long as they can get it done before the election, they can take that to the RNC and boot him off of that, or they can retake their claims for ballot removal, boot him off of that, or they can just say he can't even vote for himself, like Chris Christie, like a broken record, and then to try to beat him in the court of public opinion, right? Options are many. But the right to a speedy trial doesn't mean that the prosecutors take meth and then prosecute you as quickly as possible, and the defense just like gets dragged along by it. No, the defense needs time to review the discovery. There are 13 million pages plus in this case, plus tens of thousands of hours of footage, I think is the number, and it is basically impossible for them to get it done from August to March to review all of the discovery. So Trump has a right to have this extended so that he can do his due diligence to actually review the evidence so that he can prepare his defense. And they're not really considering that at all, right? Because Chutkan doesn't care about that. And the case that we used for comparison was Walmart versus Visa, which had, I think, 8 million pages of documents and took 7 years to litigate. So just do the compare and contrast. It's like 7 months versus 7 years. Trump has 13 million documents. Walmart versus Visa, the two most biggest, some of the most behemoth companies in the world, 7 million pages or whatever the numbers were in that range. So they say the public and Trump and the government are entitled to nothing less. We have to go very fast. But if this case proceeds through the ordinary and even a highly expedited appellate process, Jack Smith says it is unclear whether this court would be able to hear and resolve this threshold immunity issue during its current term. That means we're going into 2025. And that insurrectionists might escape trial. So for that reason, Jack Smith says, the government seeks a writ of certiorari before judgment to afford this court an opportunity to grant review now and ensure that it can timely resolve the important immunity question that is presented here. Says the United States recognizes, yeah, this is Jack hitting the panic button, oops, that this is an extraordinary request. Interesting. I remember some other extraordinary requests that the Supreme Court just threw out. Remember when Ted Cruz and a bunch of attorneys general had a very big emergency request in 2020? Can you please intervene and stop this election from being rigged? And the Supreme Court was like, we're busy. Sorry. So what are they going to do here? Jack is in a real big hurry. Supreme Court could basically just say, let's let the Court of Appeals deal with it. Move your trial date. This is an extraordinary case, which is a little bit of an about face. Okay, because remember when Trump was in there in Chutkan's courtroom, we had all the different transcripts from Jackson. He's like every other criminal defendant. He doesn't get any special privileges. Even Chutkan said, I don't care about the election. Chutkan said specifically, I don't give a whip about the election. So what is so extraordinary, Jack? Why is everything changing right now? What are you so freaked out about, man? This is just a regular defendant, just like anybody else. So they say this court should grant certiorari and set a briefing schedule that would permit this case to be argued and solved as promptly as possible. Man, he's nervous. Please, please, please. My homework is due. I need time. They say this case warrants immediate review. Why? This case involves a paradigmatic issue of imperative public importance. Let's see. The amenability to a criminal prosecution of a former president of the United States for conduct undertaken during his presidency. All right. So like that I agree that is an important public issue, but why is it important now? Like, why do we need that settled right now? Why can't we just resolve this, I don't know, a couple of years from now? Now, it requires no extended discussion to confirm that this case, involving charges that Trump sought to thwart the peaceful transfer of power, they say, is at the apex of public importance. Maybe for these people, I think they, have a hard time going to sleep at night. They wake up in cold Trump sweats. They say this implicates a central tenet of our democracy, which they don't care about. It's really ridiculous. They shattered 234 years of democratic norms. Thanks, guys. And the charges allege that Trump conspired to transgress the law, intentionally using fraudulent means to obstruct an election. Now, the district court set the trial. We know that. Precedent, they say, allows us to go fast. This case warrants a similar speed like other cases. And the court should order expedited briefing. We're filing now because not only is this publicly significant, but we want to ensure that this case is argued this term. Why? Why, Jack? Tell us. As noted, trial is scheduled to begin on March 4th. Trump has appealed. Now, given the uncertain timing of the appellate proceedings in the ordinary course, including potential requests for rehearings, certiorari before judgment, like why we skipped over the Court of Appeals, is appropriate to allow the court to provide prompt review. And because this court has some discretionary matters, we're also concurrently filing documents in other courts, which we'll review in a later segment. They say if this court grants review, if Supreme Court takes it, the government respectfully requests it establish a schedule for briefing that would allow this case to be resolved as promptly as possible so we can get this trial on track. But if the court opts not to grant review immediately, the government respectfully suggests that it consider postponing action on the petition pending further proceedings in the Court of Appeals. So the court could grant certiorari immediately. Like, if you're going to make us go through the Court of Appeals, can you please make sure your printer is on? Because we're going to send our petition right back to you, like, as soon as we get it. And if the court elects not to review the case at this time, it may wish to note that the Court of Appeals should proceed with sufficient dispatch to permit the court to hear this case promptly during its term. Now, the petition is respectfully submitted by Jack Smith, special counsel, who's a little bit nervous over there. Oh, because he's got a rush, man. He's got just a short amount of time to get this thing going. And so they submitted an entire appendix and the rest of their filings here in the remainder of the document. But you can feel the nervousness there, right? We were waiting for this, but what we were expecting to see was Trump filing these appeals and landing at the Supreme Court, not Jack Smith. But he's nervous about it because the clock is ticking and they are in serious cope mode over there on MSNBC. They brought out Jack Smith's #1 fan called Andrew Weismann, and he is explaining the news, saying, this is a pretty smart move if he's going to try to maintain the March 4th trial date. See, that means this is already probably lost. That March 4th trial date probably getting moved. Here is Andrew Weismann explaining.
Breaking news, special counsel Jack Smith's office has just informed the D.C. Circuit that they're going to ask the Supreme Court to immediately take up Donald Trump's claim that he is immune from criminal prosecution for the official acts taken as president. Trump's lawyers argue that his D.C. indictment should be dismissed. And joining us now is former senior member of the Mueller investigation, Andrew Weismann, and New York Times investigative reporter Suzanne Craig. So, Andrew, your reaction to Jack Smith taking that immunity claim immediately to the Supreme Court, I guess that was automatic.
This is a very smart move on his part because there is a March 4th trial date. And one of the exceptions with respect to appealing things, normally you have to wait for your trial to be over before you can appeal. That is not the case with respect to claims by Donald Trump that he enjoys presidential immunity with respect to all of the charges. It is also not the case with respect to his claim that double jeopardy is attached and he can't be tried twice. Now, the district court denied both of those in a very cogent opinion.
Chutkan, it wasn't
and
cogent.
That is now on appeal to the D.C. Circuit. But there's an automatic stay that applies during that time. So that would jeopardize the March 4th trial date. So what Jack Smith has just done, and minutes ago, is asked the Supreme Court of the United States to go ahead and decide the case now. In other words, leapfrog over the D.C. Circuit. That is permitted under Supreme Court rules. And one of the cases that Jack Smith cites in support of the Supreme Court doing that is United States versus Nixon, where the Supreme Court, according to Jack Smith, did just that in order to expedite the hearing. Now, we'll all wait and see what the Supreme Court does, but this is a smart move on his part in order to try and maintain the March 4th trial date.
Okay, it's a smart move because he's boxed in. He's got nowhere else to go. If he wants the March 4th trial date to go, then he has to get the Supreme Court to come in because Trump is just going to delay, man. He's going to drag his feet on it, as he should, as is his right. That's what they get for dumping 13 million pages of documents on him and saying you have to review it in a matter of months. You can't do that. He has an absolute right to explore these things. Maybe they should have prosecuted him a long time ago, not in election year. Trump got some good lawyers, and they have articulated this appellate process, and they've timed it beautifully. And now it seems like the Court of Appeals and their process might cause the entire trial date to move. And so we'll be here continuing to cover. There will be some serious consequences on this. Hopefully we know what the Supreme Court says sooner rather than later, but we will be here continuing to cover this appeal and the others, as we're going to cover. We've got more segments and different courtrooms to attend to, but we'll be covering all the Trump trials. So my friends, thank you for subscribing wherever it is you're watching this. Thank you for checking out robertgovea.com if you want to access any of the documents we went through, and we'll look forward to seeing you on the next one. All right, now let's stick with Jack Smith because he filed a bunch of other stuff related, but this one is not at the Supreme Court. This one is to the Court of Appeals and to Judge Chutkan. So let's see what he's saying to her. Jack Smith, very nervous about that March 4th trial date, and he's asking Judge Chutkan to hold the line. Don't move it. Even though he's appealing to the United States Supreme Court, even though Trump is appealing to the D.C. Circuit Court of Appeals, Jack Smith is asking Chutkan, let's keep this train on the tracks. We want trial on March 4th, the day before Super Tuesday. And so we're going to go through this very short filing just saying, hey, you don't have to change a thing, Judge. Keep this going. Then we're going to go right up one level to the Court of Appeals and see what he's telling them before we see what Mitt Romney has to say about Donald Trump and about all of this stuff happening. But first, this is Jack Smith. Now, motion to stay the January 6th proceedings was something that Donald Trump filed, saying, I want to stay the proceedings while this is all sorted out, as is his right. Jack Smith is responding to that, saying, I oppose Donald Trump's efforts. So this is out of the D.C. Circuit, D.C. Court, out of Washington. 3 pages, very short. We'll take a look at the one that went right up to the Court of Appeals in a minute. Jack Smith's team, in this case, it's Molly. Highlight our girls here. Let's see what she says. She tells Judge Chutkan, hi, Your Honor, the court should deny Donald Trump's request for an order staying, quote, all district court proceedings while his interlocutory appeal is pending. Molly says, Trump incorrectly suggests that such an order would simply memorialize the automatic divestiture rule from Griggs. And Trump basically wrote in the preceding motion, the one preceding this, Chutkan, you have no choice. Thanks for playing the game. But once we filed this and appealed it, you're on notice that you're done. And so they're saying not quite. Under Griggs, a notice of appeal divests the district court only of control over those aspects of the case involved in the appeal. All right, so she's trying to split hairs on this, saying, well, some of those things I'm going to be appealing, that Trump is appealing, but other parts of the case, like, you can keep working on. Like, if you're upset with the garage, you can keep using the kitchen, right? It's just separate. And we're going to keep using the garage and just keep, the house is still functional. So they say during the pendency of the appeal, writes Molly, any number of matters could arise in this case that are not even involved in the appeal. And this court should not enter an order preventing it from handling them. And we're going, what kind of things? Like, what kind of matters could arise? I don't know. It says, furthermore, the court should maintain the March 4th trial date. Okay. And she cites a case. And she said here, determining that it was appropriate as a matter of prudence during an interlocutory appeal to schedule a date with the court. So she just wants to keep it on the calendar. She says, so to help ensure that trial proceeds promptly if the court's order is affirmed, and during the pendency of Trump's appeal, the government will meet every pretrial deadline that we've already set. So she said, we're not moving a thing. We can stay right on track. Then, as soon as the mandate returns from the upper courts, the court can then promptly resolve any remaining issues and start trial. All right, so Molly is going to be like on March 3rd, she's going to be like stretching, with the bands and all the things, like ready to go in case that mandate comes down. Now, she says the rule applies automatically upon filing the notice of appeal. And so Trump doesn't need a separate order. And the stay order that Trump seeks is way too broad. Says the court should not assume at this juncture that no issue can arise. For example, she says the circuit court recently returned a mandate talking, look at this, an order regarding extrajudicial statements. Okay. This is all about gagging Trump. Your Honor, in other words, don't put the D.C. case on pause, because if Trump says something that we don't like, we want to make sure that you maintain the court's jurisdiction over this case. Says likewise, nothing about Trump's appeal prevents the court for holding briefings and for issuing protective orders governing discovery. and also on conditions of release on Trump. So, Chutkan, you got to keep your gag jurisdiction over him, your protective order over discovery, your conditions of release. Because a big part of being prosecuted in a criminal court is that you've got shackles on you, okay? Even if you're not in physical custody, you're shackled. You've got release conditions. You might have a pretrial services person you have to talk to. Trump's got gag orders, right? You're shackled to a calendar. You got to show up in court. You're shackled to your lawyer, right? You're in chains, man, from day one. And so they want to make sure that they can maintain those chains over Trump. And this is Molly writing accordingly. So in addition, she says, while the appeal is pending, the court can make headway on the motions already before it, including Trump's motion to dismiss based on statutory grounds and his other motion to dismiss based on selective and vindictive prosecution, which are both great motions we're waiting to hear on. The court should promptly deny those motions under the rules, which provide that they have the authority to maintain jurisdiction over certain things. And she says, Molly tells Judge Chutkan, Your Honor, the public has a strong interest in a prompt trial, especially our friends at our cocktail parties. And the government will seek to ensure that the March trial proceeds as scheduled. In particular, the government will continue to meet all its deadlines, and this means that while the appeal is pending, Trump will not be subject to the burdens of litigation, and the government will continue to do our own work. And so we're going to keep working on the case. Even though Trump's not, the government will continue to give them everything. And we're going to continue to give them disclosure throughout the appellate process. And we're going to have all of our motions ready. And so they should have all of their motions ready too. So that if this comes back and is affirmed, this can be promptly litigated. And so please deny Trump's motions and decline to issue an order that they want. Signed by Molly. Molly Gaston, aka Highlighter Girl, do not move the trial date, even while they're appealing to the Supreme Court and the D.C. Circuit Court of Appeals. They want the trial to remain because it's basically all they've got. Now, this is the simultaneous appeal. This is part 3 of Jack Smith's filings. He hit the D.C. Circuit Court with Chutkan. He hit the U.S. Supreme Court. And now he is hitting the D.C. Court of Appeals as well. This one's an 8-pager. Says, the government is filing the opposed motion for expedited appellate review. Now, this is another curious angle. In criminal law, we're talking about timing a lot. Timing about speedy trial rights. Does the defendant have a right to a speedy trial? Sure. So the government can't just throw him in prison for 100 years like they did with the Count of Monte Cristo. Same thing here. But a defendant also has a right to review his discovery and prepare his defense and have due process under the law, right? The government can't just yank a defendant through the process without any process. That's called due process. And so now Trump is opposing, in this case, the expedited appeal. So Trump has filed the appeal of presidential immunity and the double jeopardy arguments, but he doesn't want to go fast. Jack Smith wants to go fast. He wants to go expedited. Trump says no. So they're saying, okay, Trump is objecting to this, but Your Honors, here at the Court of Appeals, can we please go faster? And again, I go back to the question, why so fast, Jack? It's the election. For people who say that it's not about the election, it's about the election. Now, a grand jury charged, they say, Trump in a 4-count indictment, trial scheduled for March 4th. In a single ruling, Chutkan denied Trump twice. But in seeking a stay at the district court, Trump suggested that he intended to appeal their rulings on 2 issues, immunity and double jeopardy, saying that I was already acquitted during my impeachment and I can't be prosecuted again. But Jack says, come on, Court of Appeals. Come on, man. The public needs this case to go to trial timely. And the trial cannot proceed without a resolution here. And to further the imperative public interest in a timely trial, we seek a full and final resolution of Trump's claims, whether he's absolutely immune from federal prosecution while in office, or if the double jeopardy provisions apply. They say here that the government is filing all over the place, concurrently filing motions in this court. We also went to the Supreme Court, and we've also got an expedited motion with Chutkan. Now, when the Supreme Court acts on the government's petition, the government will promptly advise this court. So as soon as the SCOTUS people rule on it, we'll come let you know. And while the Supreme Court is considering the petition, however, this court has jurisdiction. Until SCOTUS says it's theirs, it's yours. An immediate entry of an expedited appeal in this court will ensure that this court can resolve Trump's claims with enough time for the Supreme Court to hear during its current term. So if SCOTUS says it's your ball, well, we need you to go quick. And if not, if they take it, we'll let you know about that so you don't have to work on it. So expediting this appeal will avoid the undue delay and is a common procedure. So they give us a bunch of law. Hey, we ask you to go fast all the time. So just go fast here as well. They say the same approach is appropriate here. And that's particularly true, especially because Trump is claiming he's immune from prosecution. Expedited proceedings like this are appropriate based on the stage here. And here, the government respectfully asks that this Court of Appeals expedite the briefing schedule and schedule oral arguments quickly. Why? The government requests that the court require that Trump's opening brief, so Trump's lawyers are like, we order them that they've got to respond to this no later than 10 days. The government is going to file our brief within 1 week of their brief, and any reply brief should be due 3 days after that. We have to go fast so that we can get him convicted before the election. Respectfully submitted, Jack Smith and his attorney, James Pierce, who is doing some appeal work, as you can see, counselor to the special counsel. So this goes up to the D.C. Circuit Court of Appeals, all certified, and we'll see who acts first, right? Who is going to be the first one through, and whether it is the Supreme Court or the Court of Appeals, we will be here obviously covering it. Here's Mitt Romney, who is out hitting the airwaves, talking about what a maniac Trump is as we're watching this legal onslaught go against him. He is, I think, voting for Joe Biden or something. Here he is talking about how all this tyrannical behavior from the government is not really, I guess, tyrannical, and why Trump is the person we should really fear.
Do you think a second Trump term would look like?
Well, I think if you can look at the last few months of his presidency, you'd suggest that that's the kind of thing you might see.
What, trying to preserve an election, preserve a nation?
Him as he did last time, people of
Millie?
judgment and experience offering advice, and in some cases restraining his impulses. Instead, he would have people around him encouraging his impulses and perhaps adding to them. And I'm afraid you'd find the nation more divided. Look, our nation doesn't need to be divided right now. A campaign based on anger and hate may win at the ballot box temporarily, but it tears the country apart. The other day, the former president said that we are at greater threat for what is within. I think that was in some respects a self-own, because what's within, if he were to become elected president again, is a campaign of retribution and anger and hate. That's not what America's based on.
Hey, that's what happens when you win. I mean, the Democrats went in and they prosecuted a bunch of Republicans. They went after all the J6ers. They're going after people who were alternate electors in various states now. What are you talking about, Mitt? It's not anger and retribution. It's governance. It's the new governance. That's just how governance works now.
America was based on the idea of in God we trust and united we stand. Divided we fall. Divided nation is not the nation America is intended to be.
Oh gosh, is he running for president or something? What is he talking like that for? It sounds very Mitt Romney. All right, so that is what is happening out of the D.C. Circuit Court of Appeals. Jack Smith and the deranged thugs at his office are begging, whining, pleading to have the January 6th trial date scheduled for March 4th, the day before Super Tuesday. We'll see who acts first, whether the Court of Appeals will or Supreme Court. My friends, thank you for subscribing wherever it is you're watching this. Thank you for joining us at robertgovea.com. If you want to access any of these PDFs, you'll find them there, and we'll look forward to seeing you on the next one. All right, and our last big one of the day. We've got the mustache man in here as well. And we're going to have a promo in this one, but we're going to have live stream privilege on this. So we're just going to skip right over it. And this one also came out from the Court of Appeals, but it involves Trump and a victory. Hey, Rumble's working. Okay, cool. Yeah, Rumble's working. That's great news. All right, shout out to our friends over there. All right, let's get to it. Donald Trump and his campaign declare victory after the Judge Chutkan gag order comes down split. The D.C. Circuit Court of Appeals issued a 68-page opinion. We're going to hit the highlights on it. We know that they want to gag Trump. Part of the reason you prosecute somebody is to put them in shackles. He is not in physical custody, but he is gagged and he has to show up in court and deal with all this nonsense. And so Chutkan gagged him, said, you can't talk about Jack Smith and the deranged thugs over there. But the problem is Trump has the First Amendment and free speech, and we want him to be able to criticize the very people who are violating his rights. That's why we have the First Amendment. And so when Trump was gagged, Trump took it up on appeal. I think ultimately this will land at the Supreme Court, but it's at the Court of Appeals first. We'll see what it says. We're also going to hear reaction from John Bolton, who was inside Jen Psaki on MSNBC. He says Trump is even worse than Nixon, and Trump might even start eliminating his own cabinet or something like that, according to this guy. So we'll have some fun stuff to get to. First, Donald Trump declares victory on this ruling, and it's a nice one. He says, today, the D.C. Circuit Court panel, with each judge appointed by a Democrat president, determined that a huge part of Judge Chutkan's extraordinarily overbroad gag order was unconstitutional. Says President Trump will continue to fight for the First Amendment rights of tens of millions of Americans to hear from the leading presidential candidate at the height of his campaign. The Biden-led witch hunts against President Trump and the American people will fail. That's from Stephen Chung, a Trump spokesman. So this is what the opinion looks like from the D.C. Circuit Court of Appeals, and we're going to get right into it after a quick message from our friends. And now, the D.C. Circuit Court of Appeals, they split the gag order, as we saw. Trump excited about this, saying that a big portion of this is, in fact, unconstitutional. Let's see what the court holds for us. This one filed out of the United States Court of Appeals for the District of Columbia, the D.C. Circuit. A 68-pager. We'll hit the highlights here. And you'll notice this little thing that we see up top here. We don't see this on many filings that we cover here. This is the public copy. Sealed information has been deleted. Wouldn't it be nice to have some transparency from our own government? I mean, if Trump is such an insurrectionist, can't we just know everything about it? What do they have to hide everything for us from? It's a public person being prosecuted for a purely public crime who's running for another public office being prosecuted in a public court of law. Why is everything hidden from us? Okay, so we're at the D.C. Circuit Court of Appeals. We know that Donald Trump has appealed this, and we're expecting him to take this up another notch to the U.S. Supreme Court now that this case has come back down, but we'll see, maybe not. Here is the understanding of what's happening. All the parties were there, and the court gets us started as follows. You see, all the people were there arguing it, including Molly, including Thomas Wyndham and James Pierce and all of the other deranged thugs. And here, the judges, Millett, Pillard, and Garcia are all writing. They say, all right, here's the story, America. A federal grand jury came out and indicted former President Trump for conspiring to overturn the election through unlawful means. That happened out of D.C. Saying soon thereafter, Mr. Trump posted multiple statements on his social media account on Truth, attacking potential witnesses in the case, including the judge and the special counsel and his staff for prosecuting the case in the first place. Saying the district court subsequently issued an order restraining the parties, this is Judge Chutkan, and said that any statements that, quote, target the parties and their counsel and staff are not acceptable. Saying that any reasonably foreseeable witness or the substance of their testimony are off limits. Reasonably foreseeable witness, which is basically everybody. Because do we have any? January 6th was a pretty big event. Donald Trump was the president. A lot of people involved in his administration. So what does that mean? Do we even have a witness list? Or can they just decide Trump has said something bad and it covers that, right? It's totally amorphous. You have no idea what they even mean. So then Trump appealed the order. Now, his appeal now involves the confluence of two paramount constitutional interests. And we've said this here, right? It's the rock versus the immovable force. It's the unstoppable object against the immovable force. The freedom of speech under the First Amendment, and then the federal courts and the criminal due process. So orderly administration of justice versus the First Amendment. And I like how they reference it as Article 3 duty. Okay, so it's like they're just going to take up the entire article. All right. So they're going to take all of Article 3 of the Constitution versus the First Amendment. All right. Well, an article's bigger than a single amendment. So that the courts, you see, maybe I'm reading too much into it. I don't think so. To ensure the fair and orderly administration of justice. What, by gagging Trump? Don't give me that. Don't tell me that the entire, like, Article 3 and fair and orderly administration of justice is in any way corroborated or correlated or causally connected to Trump's gag. Ugh. So they're just going to dump on the First Amendment as though it's meaningless. All right. We agree with Judge Chutkan that some aspects of Trump's statements pose a significant and imminent threat to the fair and orderly adjudication of the ongoing criminal proceedings. So Trump loses that, warranting a speech constraining a protective order. Lose. Now, the district court's order, however, Judge Chutkan, it sweeps in more protected speech than is necessary. Obviously, the heck is a reasonably foreseeable witness. For that reason, we affirm Chutkan's order in part and also dump the rest of it. Specifically, the order is affirmed to the extent that it prohibits all parties and their lawyers from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation of this proceeding, which is insane as far as I'm concerned. I think they should appeal this. I don't even know. Unless there's a witness list, which is, to my understanding, still in flux. Like, what does that mean? Is Liz Cheney on that list? I don't know. Can they ask that? Is Liz Cheney on that list? Can he respond to her? She was there, right, on January 6th. She was there on the committee. So the order is also affirmed to the extent that it prohibits all parties and their counsels from making or directing public statements about the counsel in the case other than special counsel. Okay, so he can comment about deranged thug Jack Smith, but not about Molly or Jay Bratt, which I guess is up to us. We're going to have to keep making fun of Highlighter Girl here, I guess. You know, it's her own fault, man. She shouldn't have talked about organizing the defense discovery. What a ridiculous thing to say. So counsel in the case other than special counsel like Molly and Jay, we can't talk about them, or he can't, we can. Now, members of the court staff and their counsel's staffs, which I don't think, this is the Judge Chutkan courtroom, so I don't think that there were any concerns about games of footsie with Judge Chutkan's staff. I don't think. We haven't seen anything like that. I don't think that her clerk has been whispering in her ear playing footsie. I don't know. But I don't know if that's happening with Judge Ariola Engeron either. You know, it's just people have rumors that are being discussed because they move the cameras around in the New York case. So it's strange. Now, members of the court staff, now again, I'm not in favor of that. Now, in favor of harassing or threatening anybody because it's already illegal. Now, the members of any counsel or staff member, if those statements are made with intent to materially interfere with the knowledge of the criminal case, okay, and we vacate the order to the extent that it covers speech beyond those specified categories, which is just very, very ambiguous. So we get a little bit, you know, I'm not sure I would declare this as big of a victory as Trump made it sound, to be honest. I think that he should be free to, he should know who the witnesses are specifically. I really hate this reasonably foreseeable crap. I don't even know what that means. Because it's a broad case. There's 13 million pages of documents here, right? If I'm a defense lawyer representing Trump, I'm saying, no, wait a minute. What's the list? Because it's a big case. There's 13 million pages of materials. You said I can't even read them. So I need to know who's in there. Amazing. We've got notice and updates on SCOTUS. Now, on August 1st, we're going to just run through this very briefly just to share with you what this looks like here. It says the conduct charged in the indictment is out of Trump's refusal to concede his loss. And during the alleged efforts to overturn the election, here is some of the deleted stuff. Another official explained that he needed additional police protection and he avoided the something. And this is from special counsel. He avoided the what? Grocery store? He didn't walk his dog? Okay. And after then, Trump criticized a government office for certifying an election. A member of that office had to look over her shoulder when one of Trump's supporters posted her address online. Oh, wow. Is she a public official or what's the deal? A member of the government office? Okay, look, I'm not for harassing or doxing anybody. I don't support that at all. But then, okay, Trump singled out private individuals. He singled out an election worker, and they're mentioning that, which I think Rudy Giuliani is on trial for. Then Trump said this, if you go after me, I'm coming after you. And he posted that on 6 million follower Truth Social account, which is true. This is politics, right? This is just how it works. Now, they prosecuted him 4 times with 4 different criminal indictments. It's fair game, man. If he gets control of the judiciary, what do you think's going to happen? Everybody who was part of this vindictive prosecution, partisan lawfare attack, it arguably is committing crimes, right? Under a different interpretation of the rules. So if they're going to interpret the rules to prosecute Trump, well, he can interpret the rules to prosecute them, right? It's just how this works. It's capture the flag. So that's why they're so freaked out. Now, the district court first explained that Trump could comment about D.C. Trump said this was a significant risk to him. And then a lot of procedural stuff here. So you can see. Now they say that we begin here with our jurisdiction. After all of that, we begin. And we have the authority to hear this case, talking about collateral order doctrine. And the idea is that Trump has the right to appeal this, even though the January 6th case is not completed yet. It's not done. His gag is limiting his ability to speak, which is causing him actual harm right now. We have jurisdiction under that doctrine. What are we going to do? Whether the order violates the Constitution is a question of the law subject to de novo review. We're going to review everything fresh, like it's brand new in front of us. Saying 2 constitutional values intersect here, the right to free speech and the right to a fair and functioning criminal justice system. Now, they give us some First Amendment stuff. They say political speech is the lifeblood of American democracy. It used to be. We don't have much of it anymore. It allows the free exchange of ideas among individuals about governance and political process. Yeah, would it be nice? And that's from another case. Now, whatever difference is, we should be able to talk about it. And for that reason, the First Amendment has its most fullest application to political speech. Free speech also holds government officials accountable, including deranged thugs and partisan hack prosecutors. As relevant here, speech about judicial proceedings, especially criminal proceedings, promotes transparency in the legal system and guards against the miscarriage of justice. And so we need adequate breathing space for robust speech. In addition, even protected speech may sometimes be regulated, though. And Trump, like all people, does also have a fundamental right to a fair trial. And this is going to be curious. They say Trump's right to a fair trial does not give him to insist upon the opposite of that right. That is a trial that's prejudiced in his favor. So I guess Trump is going to be speaking too loudly that he's going to bias D.C. And the courts must take steps to protect the integrity of the criminal process. And so they can abridge speech, right? They say their speech generally can be abridged if there is a clear and present danger to the administration of justice. Now, that is a phrase right there, clear and present danger. Is what Trump is truthing about meeting that standard? Courts have an obligation to protect the court system. And while courts have quite limited authority to silence speech, sometimes they do. In this case, we found that they did. The Supreme Court also held that the First Amendment allows the court to prohibit the speech of a trial participant when the speech poses a substantial likelihood of material prejudice to the proceeding. Now, they say the court was explicit that the standard applied does not apply to speech by a lawyer whose client is a defendant in a criminal proceeding, because lawyers are officers of the court. Now, the question is for who? Like, what are we protecting and for who? Is it the defendant who wants the limitation so that the defendant can get a fair... Does the defendant want speech limited so that he gets a fair trial, or does he want the speech to be broad so that he gets a fair trial? Now, in that case, it involved regulating the speech of counsel for a criminal defendant, but it also says that the court has the authority to control. Criminal defendants are frequently subject to substantial liberty restrictions. It's true, right? And this is what they say. No, you already have to show up. You already give up your right to travel. You already give up your right to leave the country. You already give up your right to go do this and go do that. So why not your free speech too? To sum up, they say, the Constitution requires a robust protection of speech about criminal trials and the government's effort to deprive a defendant of that liberty. Now, at the same time, it requires courts to ensure that outside speech does not derail the criminal process. And on this record, they say the constitutional path for the presiding judge to protect both free speech and fair and orderly administration was not to limit what outsiders can say about the trial, but to appropriately delimit whether trial participants, including the accused, what they can say publicly about other witnesses or outsiders. And so they say, we hold that Judge Chutkan had the authority to restrain Trump's speech that present a significant and imminent risk to the fair and orderly administration of justice, and that there's no other less restrictive alternatives that would adequately address this. And so we hold that it was not narrowly tailored, and we modify its scope a little bit to bring it within constitutional bounds. Signed by the D.C. Circuit Court of Appeals. And the opinion goes on, but you see the thrust of it there. And it is now up to Trump to see whether or not he will be appealing this and taking this up to the higher level courts. But Trump is declaring victory because a portion of that was found unconstitutional, and he now can talk about Jack Smith and the deranged thug that he is, and according to Trump. And he's not allowed to talk about the other prosecutors, though, so it's a partial win there. Now, this is John Bolton, who we know likes war everywhere he turns, and he was inside Jen Psaki on MSNBC's #1 show, and this is what it sounded like, saying, you know, that Trump is acting like somebody who's even worse than Nixon with all this speech and all this talking and all of this lawyering that's happening. He's the worst. Here's what it sounds like.
I want to start with this. I mean, you have dealt with dictators. I mean, in your role as a national security high-level official over the years, do you see similarities in some of the tactics that Trump is taking to what you've seen from authoritarian dictators?
Well, certainly what he has tried to do in the past and what he's saying he's going to do in the future go well beyond any conceivable conduct by prior American presidents, no matter how much they were considered. Richard Nixon looks like a choir boy next to Donald Trump. So I think it's him saying these things publicly. Ironically, I have to say I hope will be helpful because I think people should wake up to the reality. And although the polls don't look particularly good on the Republican side, to continue to make efforts to deny him the nomination.
I want to start with this. I mean, you have dealt with dictators. I mean, in your role as
all right, so that's the Walrus, I think is what he was called, often talking about Trump and what a maniac he is, even though this guy was the person taking us into war after war after war everywhere you turn. Now, including more TDS is this guy. Now, he's worried that Donald Trump might actually eliminate people if he's allowed to squeeze through this legal maneuver and escape criminal culpability for what they say is insurrection and other things. Then Trump literally might be able to eliminate people in his cabinet, might be able to just go in there and just take out his vice president. Let's listen.
I screenshot this and highlighted it. You write, the existing constitutional system has no room for the subversive legal maneuvers of a criminal in chief. If a president can pardon himself for federal crimes, as Trump would likely try to do, then he could write his pardon in advance and shoot visitors to the White House.
Yeah. He's going to claim a right of self-pardon, but think about it. If the president can pardon himself for criminal offenses, that means he can shoot the first lady. And maybe he's impeached, but nothing. You know what else
Melania?
It means? Even weirder? It means the vice president can pick up a pistol,
Why would he do
walk
that?
into the Oval Office, shoot the president dead, and say, I'm the president now, pardon. And
Wow.
although, again, maybe there's an impeachment, no criminal penalty. That is so crazy, it can't be right. But that is what we're going to be debating 2 years from now if this man returns to office.
Right. It's incredible.
Okay, well, it sounds pretty exciting, actually. It sounds like kind of like Game of Thrones or something, you know, like Survivor presidency. Trump did have The Apprentice, you know. We could call it The Presidency, starring Donald Trump. Oh, you want another war in the Middle East? Sorry, buddy. You're gone. You're fired. You know, I don't know what the story is over there. It sounds exciting. We'll have a lot less bureaucrats. It's a joke. I don't endorse what this guy is deluded about. He should probably get a therapist or a counselor or something. You know, I don't know, but he sounds like he thinks that everybody's just going to be shooting each other in the Oval Office if Trump wins. So, all right, my friends, that's what they're talking about over there. And that is the gag order, okay? If Trump is allowed to speak or exist, people are just going to be dropping dead in the streets, according to them. And it's a wild scene. Now, we'll be here continuing to cover these trials and more, my friends. So thank you for subscribing wherever it is you're watching this. Thanks for sharing the show with a friend or family member, inviting them to come over here and join us when we go live. We have all of the PDFs available at robertgovea.com, so you can go over there, sign up for our daily newsletter, get all these segments bundled up, delivered right to your inbox so you can forward the news stories onto your friends and family. We'll be looking forward to seeing you here on the next one. All right, my friends. Well, that is what we had on the day. Trump declaring victory on the gag. Jack Smith urging the trial date to remain in March. And then the panic at the Supreme Court from Jack Smith. Getting a little bit nervous there. That March date looking like it is fleeting. But now, my friends, it is time to hear from you. Let's see what you have to say about this over at watchingthewatchers.locals.com. I saw some very nice, very generous donos come in on the house. And thank you, Zach Nichols, for clipping these for us on the day. Couple donos. We got Glenn Croy coming in. What's up, Glenn? Glenn's bringing in new membos. We got Mama Rocks, Janine S., Adam K., and Joshua G. all coming in as new membos, courtesy of Glenn Croy in the house. Thank you, Glenn. We've also got Fred Petamonte says, the longer it takes, the more info comes out about January 6th. And it's dripping, dripping, dripping. In fact, our friends on Rumble, Chris Pavlovsky, the CEO of Rumble, said that he thinks that some of their attack might be due to the fact that they're publishing the J6 videos exclusively on the Rumbles. CF Rob says, I think the technical issues with Rumble this morning was big tech's anger over Elon Musk on suspending Alex Jones. Ooh, yeah, that was fun. Alex Jones and Elon were having a conversation with Vivek this weekend. It was a wild scene. And then Vivek had to, relieve himself. Alex Jones is back. Rob, interview Alex Jones. Do a poll. Should I interview? Man, I'd love to talk to Alex Jones. Are you kidding me? Are you kidding me? Maybe we could pull up the documents on the screen and redline them together. The documents, man. I'd love to talk to Alex Jones, but I think, we got to get a little, he's kind of a big fish out there. So, I'm not sure if he'd come talk to us, but one day soon. We got Brandon Lesko. Says, Rob, have you been reading your inbound baby books, Rob? I got them all, man. I'm learning what to do. We have so many babies coming up now. I'm learning, what should I do? My kid, his vomit looks like this. Why does his doo-doo look like this? I'm curious. What age should they start walking? Why is my child not walking? Is my child, the things. So I'm learning a lot, man. I'm learning a lot. It's madness around here. But Brandon Lesko, you're about to pop, my friend. Looking forward to seeing our little soccer player soon. We got Ms. J. Says, I love you and your show. You make my day. Well, thank you, Ms. J. Thank you for saying that. Your comment made my day. Thanks for joining us. And I love you back. Thanks for being here as we go through all of this together. We've got the good doctor over on the locals. Says, by what right does Jack Smith appeal to the Supreme Court? Don't they agree with Chutkan's ruling? Yeah, right, exactly. Doesn't this appear like he's overreacting or overreaching? Smith doesn't have a good reputation with the Supreme Court. Totally. Yeah, I mean, I agree with you completely. It feels like he's panicky. Like he needs this. It's like, why are you asking, Jack? What do you need them to hurry for? I thought your case was all settled and figured out. Oh, you're nervous. That's right. We got B. Torn says, to me, far too many U.S. Supreme Court decision scenarios and flat out rejection to get hopes up for Trump. The court could even put a hearing on their spring docket. You're right about that. Yeah, they could. I mean, they could be like, I don't know, holding hearings when does that start? October? Like they could hold hearings in October. I think is when the docket starts. They just put them on in October. Yeah. Oh, great. October surprise from the Supreme Court, Trump's case. I'm not sure they're going to do that. You know, it could go the other way, but I think the big thing that they really wanted, that they're upset about, is the trial date. They want that to happen in March. They need the conviction. And if they don't get it, the whole calendar's off. Don't you hate that? NY says, in his filing to the Supremes you just went over, Smith acknowledged that the proceedings were stayed during the appeal. Now he's opposing it in his other filing? Isn't that misconduct? Well, they were being very clever about that, right? So she said that, you know, it's only so that we can go if we're ready. Like, we're not actually doing any work, court. So Trump, it is stayed and Trump is alleviated of the burdens of litigation, but it's ready in case you need it, right? So she's splitting hairs. I wouldn't call it misconduct, but she's splitting hairs. And it's Chutkan. What's Chutkan going to do? Report her to the bar or something? Pfft. Now, NY says, throughout his motions, Smith quotes a public interest in a speedy trial. The public doesn't have a right to a speedy trial. They never ask the, quote, public to waive it when waived. Doesn't Smith have to state only facts and law in his pleading? No. I mean, opinion also, right? Like opinion, he's making an argument. So he can definitely make arguments and stuff like that. We've also got Glocky McGlockface says Romney and Cheney are not good people. They move to states they aren't from. They go against those states' voters and then they leave when they lose. That's right. They both did that, didn't they? Yeah. Romney was like a Massachusetts guy for a while, like a Massachusetts, like kind of pro-lefty, kind of a Democrat, Ted Kennedy type of guy. And then bailed over to Utah. Right. Same thing with Cheney. Cheney's like, I'm going to go hang out where my dad lives, Dick Cheney, in Jackson Hole, Wyoming, and then goes there, you know, carpetbags for a while, gets elected, then gets obliterated after she changes sides. And the left is like still a big Cheney fan. And like, do you remember who her dad is? Like how much you guys hated him? What is it with them? I don't know. I think they just like to be abused or something. Mr. J says, SCOTUS just granted the petition sent by the Supreme Court. Trump has until December 20th to respond, 9 days. And Barb's loves Alaska is flashing that too. Just saw on X, flash. Supreme Court agrees. Oh man, let's see. It says Supreme Court agrees to special counsel's request. Let me see if I can find that story while we are here and see if it's probably not going to be anything substantial. Yeah, here it is. Thank you for flagging that. This one came over from Scott McFarland. It says, flash, Supreme Court agrees to special counsel Jack Smith's request. Trump must respond by 12/20. There it is. Very short notice. Order in a pending case. United States versus Trump. Petitioner's motion to expedite consideration of the petition for a writ of certiorari. So Jack Smith's request that really speed this up is granted. And Trump is directed to file a response to the petition on or before December 20th, 2023. Woo! So, man, we're going fast. I like it. It's going to be a lot of fun. So this will be, we'll be covering this, my friends, and we're getting spicy. We're getting spicy now, and we're looking forward to it. All right, so we thank you for that, Mr. J. Thank you for that. Barb's loves Alaska. You guys are bringing us news in real time. That is fresh out of the oven. You know how much we like the fresh ones. We got NY says, the ruling would allow Biden and his campaign to opine at will, say a hypothetical debate that will never occur, and Trump would be gagged. Now, that's what they're in here for. Use the criminal justice system to gain a tactical advantage. Brandon Lesko says, I'm behind, but let's say a president dropped a bomb on citizens abroad, like Obama did when he took out those kids, that one kid who was a U.S. citizen, or a nuclear bomb. I would assume these laws protected that for a reason. Well, yeah, so a president would be, I would say that would be within his powers as the commander-in-chief, right? So he's qualified to do that. Like, that's his job. Just like it's the president's job to execute the laws of the country, including elections. So he's protected by that, by virtue of not only his presidency, is also protected by the First Amendment and other things. But yeah, if it's within the confine, now if he dropped a nuclear bomb and, was not the president and didn't have the authority to do that, yeah, that'd be a criminal. That would be a crime. And he could not claim presidential immunity from that. We got B. Torn says, far too many decisions, says court could refuse to reply to, but the court could put their hearing on the spring docket. And we had Jonathan Manson says, Jack Smith never mentions the RNC calendar or the demands of multiple other criminal cases in his rushed filings. This is a material omission. Agreed? In other words, the Jack Smith, well, I don't know. I mean, I think that it's been Chutkan's position, at least as the I don't think it's material for Jack Smith. I'd say that those are Trump's team's things to include. Now, the RNC calendar, I think Chutkan has already basically made the point, so it would be a useless point for them to respond to. She's already said, I don't care about the election, like, at all. Like, at the outset. Like, don't even talk to me about the election. And that's why the trial is scheduled for March 4th, which is the day before Super Tuesday. So, like, all of the other, anything RNC calendar related, anything like that, I think that Jack Smith could get away with not including that. And I don't think he really knows. Yeah, I think it's Trump's responsibility to let the court know about his calendar. But yeah, Jack Smith, if he was a decent prosecutor, would not file things so quickly. He'd say there's also 3 other criminal cases that are pending. But obviously he's not going to do that because he's on a one-mission track. Thank you, Jonathan. Good question. We got the blind lawyer says, so there is no immunity for presidents? Not according to Jack. Great. That means no immunity for judges and prosecutors too, right? No, they get it for whatever reason, but the president doesn't. Nobody is above the law, right? No, every government officials across the country are all over the place. It's literally what qualified immunity is. It's everywhere. So the blind lawyer, good to see you. We got this one from Voice. Says, Rob, you never know till you try. Reach out to Alex. And if needed, I'll try to use my connections for you. You got connections, man? I wouldn't even know how to start. Just send him a message on Twitter. Hey, man, you want to come on my show? I don't know. It's a good idea. It's a good idea. Why not? You never know until you try. Kaiser of Third Age, a membo for 5 months or over the hump on the baby. Says, good show, Rob, and good day, watchers. Thank you, Kaiser. Kaiser of Third Age. Membo in the house. Very nice to see you. We've got Sweet Tat. Says, I'm about to pop, Rob. My head is coming out. Oh, no. Says, I'm about to pop. 8 months. You are about to pop. Yeah, and that baby, you can feel that baby's kicking. Gonna be a boxer, gonna be a soccer player. We don't know yet. But coming out soon. 1 month to go. A membo for 8 months. Sweet Tat in the house. Good to see you, Sweet. And hey, this is from Barb's. Barb's flagged this over for us on Rumble, too, which I'm really glad that Rumble is working. That's great. And we'll see if we can do our after party over on the locals. We've got, so thank you for that, Barb's. Trump must respond by 12/20. Flash on the X. We got TL's over here. What's up, TL? Thank you for being a membo. Says, can Trump say, quote, since I'm underestimated, this gag order, the Dems say me telling you the truth is a clear and present danger. Trump needs to use Caesar's speech, Brutus and Biden is an honest man. Interesting comment there, TL. Yeah, I think Trump could talk about the gag order and say, see, I'm under, see what they're doing to me. Like, look at this. I can't even talk about this. I can't talk about this. I can't talk about that. That's what they're doing to me. I think that would be a good tactic to just, call out the censorship, highlight the censorship. Hey, and Pinochet's helicopter tours says Romney ruined Massachusetts. He put in Obamacare before it went national. I remember that, man. And I remember Romney was really bragging about that for a long time. Romney was, I was the architect of this because I'm so smart and all the things. And then when Obamacare passed, like all that stuff from Romney got deleted. In other words, in 2012, in 2008, Romney was all about solving healthcare. Then Obama won, and he beat John McCain, right? That was 2008. Then in 2012, after Obamacare passed in the first term, then Romney ran way away from Obamacare, or from Massachusetts care, or in this case, Romney care. He's like, I don't know what you're talking about. And, Romney felt very waffly in that regard. Scott Zajac is here. What's up, Scott? Said the polls are very relevant to the legal issues, are very relevant to the freedom of speech issues. The presumptive GOP and the presumptive nominee can't be restricted without interfering with the election. I agree, Scott. And that's why if this March 4th trial date doesn't hold, they can't reschedule it in 2024, right? They can't reschedule it in July or like October. They might try to, but, come on, guys. It's a little too late. Yeah, SCOTUS is taking the case. All right, so it's going to be fun, my friends. Let's see what's happening over on the X before we wrap it up and figure out our after party situation. Locals, friends, we're going to try to do our after party on locals today. We're going to see if it's working. In fact, let's just try it as we're here. We'll see if we can multitask and see if it's working. So we'll test that. We're also going to jump on over to the X platform and see who is on the X. We got 48 viewers. Oh my goodness. It's an X miracle. It's almost 50. I don't know. Elon must have given us a boost or something. I don't know what the heck's going on here. But hello to our friends on X. We go live every day. I'm going to act like I've been here before. And we will see what's up over there. Okay, who's on X? We got Fred, Danny, David, Michael, Darkside. We got a couple good comments here. This one is from Operation Reciprocity. Says, likelihood that the gun charges for Hunter get thrown out? I don't know, less and less by the day. So Hunter filed a bunch of motions, a slew of motions today that are juicy and just like ornery, hunty, like very Hunter kind of crackhead motions. Here, I mean, they're fun motions from a defense perspective. But let's see what he dropped today. Oh gosh, these are great. So this is against his daddy's own DOJ. Oh, these are great. Look, look at these. Oh my gosh. Oh my gosh. Look at all those exhibits. This is just incredible. So Hunter did not get the memo, okay? Like the DOJ gave him a backhand and said, hey, dum-dum, you idiot. You should have taken the stupid rigged plea deal that we gave you. And they did not get the memo. So this is going to just be fun. They are so dumb. Oh my gosh. Look at this. Motion to dismiss the indictment based on immunity conferred by his diversion agreement. Something we called a long time ago. They're going to say the deal, like this is why he should have taken the deal. If he would have just taken it, he could have made this argument later. Like he could have made that same argument right now. But now he's got a whole nother set of charges in California. Man, they are so dumb. This is bad lawyering, my friends. He should have been talked into this plea deal. So anyways, now this is going to be a lot of fun for us. Like this is very exciting for us. This is Joe Biden's son versus the DOJ. He's saying, you guys rigged my deal. I already had immunity. Like you already gave me immunity and then you are withdrawing that. So that should be fun. Look at all these exhibits. These are probably all emails and stuff. Here, let's just pick one of these out. Yeah, there's an email. Boom. Yeah. Oh my gosh. We're going to get to read all of the emails back and forth. They're going to just throw. Oh. So this is Christopher Clark with the announcement of the two agreements. It's my understanding that the 5-year investigation into Hunter is resolved. Hunter's going to take responsibility of firearms. Like the plea negotiation emails are here. So Hunter's lawyers are exposing the DOJ's rigged plea deals. Like shout out to Hunter's team. I can't believe we're going to get to see all this. They're exposing the emails back and forth between the DOJ and Hunter. This is from USDAE, copied Leo Weiss, Derek Hines. Thank you for your call. Here's the attached documentation. So they're showing, right? Hey, this was the term. Like, these were the terms. The DOJ rigged it for us, and now they're withdrawing their rig. And they're making the argument, motion to dismiss the indictment because they already gave us immunity. Now, they should have taken the deal and then just made this argument later, but they're also going to say motion to dismiss for failure to charge a constitutionally permissible offense. And the DOJ is going to have to respond to every one of these. And the DOJ is going to have to swing hard. Otherwise, they're going to lose the case. And they're going to look like total fools. So it's wild. Hunter's lawyers are rubbing the DOJ's noses in it, and the DOJ gave them a good deal, like a really good deal. It's crazy. This is crazy. So a motion to dismiss based on the appointment and the appropriation of special counsel Weiss, which I agree was a totally hack thing. But they did it to benefit Hunter. Like, they did all of this for Hunter's benefit, and now he is trying to get his case dismissed. You could say that the DOJ, maybe they want it dismissed, but, and maybe they botched it and they gave him an opening to make these arguments. But look, same argument like that Trump is making, a motion to dismiss for selective and vindictive prosecution. Okay, but Trump is actually being prosecuted. They gave this guy a ridiculous, insane diversion deal. And they want a motion for a hearing on the discovery on it. It's wild. So it's Hunter versus his dad and the DOJ that was already rigged in his favor. He's throwing a temper tantrum because he got indicted in California and now he's digging his heels in. And this is just going to be wild. So it's going to be a lot of fun to unpack that one. So we'll see when we can squeeze that one in. Maybe that will be tomorrow. But yeah, that is a juicy one. And that was from X, actually. It was, where the heck did I get on that tangent from? Okay, we got TM1 says, so Jack Smith is trying to get the SCOTUS to make something illegal so he can justify the charges he already filed. He's asking them to interpret it so that his case sticks. Essentially, there's ambiguity about presidential immunity. He's asking for clarity on that. Hey, M Money says, I noticed Psaki and Bolton are both sitting in high chairs. You think that means something? It could. I'm not sure. Darkside is here. What's up, George? George is tagging Alex Jones. Darkside says, I've come to the conclusion that Jack Smith is the same guy that sat in a classroom on Fridays just before the last bell telling the teacher, you forgot to assign your homework. That's that guy. Definitely. Michael O'Toole, he knows he has no case, but who knows if the court will actually step in. David Hauser says this could backfire on O'Biden. Danny says, if you're indicted by a grand jury, do you have the right to face the jury, aka face your accuser? Not at the grand jury proceeding. Not at the grand jury proceeding. That's just the probable cause determination portion of the case. You have the right to, there are things you can do to present your side of the grand jury, like in front of the grand jury, but you can technically, I think, appeal, and you can technically appear in front of a grand jury. It's just not advisable. It's not something that you regularly do. But I think technically you can. And there's different mechanisms to do it. In Arizona, it's called a Trevis letter. Here, Fred says, here, you said it's her court. She can do whatever she wants. I think that's the problem. Judges have too much power. They decide recusal. They can be biased 100%. Nothing can be done. Question mark. Well, some things can be done. We're covering it here, obviously. There's appeals. There's claims like what Elise Stefanik did. Like, we cover a lot of the things that are done. But ultimately, it's their courtroom. And so unless they're, taken out on appeal, or unless there's something that takes it away from them, they have a lot of authority, as we're witnessing. Good to see you, Fred. And so that, my friends, is it from us on the X. We have a couple other comments. Mama Rocks. Oh my gosh, Mama Rocks says, been here since you had 300 subs. Love your passion. That's a long time ago, Mama Rocks. Thank you for being here for so long. It's amazing. It has been a wild ride. It's a very different channel than it was at sub 300. That's for sure. And we're just getting started. So thank you for being here, Mama Rocks. And thanks for saying that. How fun. We got this one from Noisy Ninja. New name over on Locals. Welcome, Noisy Ninja. Which I'm sure you're still a very good ninja anyways if you're noisy. Says, can Trump respond to SCOTUS with Jack Smith's earlier claims that the trial was normal and not an unusual case, countering his petition? Yeah, I think so, totally. So, I don't know what Trump's going to do. Well, obviously, SCOTUS has already ordered his response, but yeah, I would point out those hypocrisies. It's funny, Jack Smith continues to say that this case is very standard and normal, and we don't need any discovery. In fact, discovery is all organized for us. It's a pretty straightforward case, but then say it's all unusual and now everything needs to be appealed. Yeah, I would point out that hypocrisy all day. NY says, what's the chance that Smith provides oral arguments to SCOTUS? Given his past, I would assume he is at a disadvantage. Probably low. NY says, Alan Dershowitz to the rescue for Trump at the Supremes. NY says, I wonder if the deal from the Biden's donors to pay his legal fees hold up if it's obvious Biden loses. Bye-bye Malibu rental. Yeah, and from Kevin, his so-called friend. B.H. Williams says, what happens when you force a prize fighter to go into the ring for a fight he doesn't want to do? Usually doesn't do well. Hard to win a race that you don't want to be in. You got NY says, some of the deal was kept from the public. If Biden asserts the old deal, how can it be kept out of the court filing? I'm not sure what deal. Well, it's not. I mean, see, he filed some of it. So what we're seeing is he filed some of the actual records, some of the email records. Flash says, Rob, I believe if we all promoted a post on Alex Jones's account with an invite to the live, he may see it. So post to the invite and let's boost it. Man, I love the enthusiasm for Alex, man. Great ideas. Yeah, we'll see if I can figure something like that out for sure. That would be a lot of fun to chat with Alex. And so, my friends, those are from our locals, friends. Locals, we are going to start a new thread to see if it works. And so go on over there, watchingthewatchers.locals.com. We're going to start a new thread as soon as we're done here. So head on over there. That, my friends, is it for us on the day. So we're firing up a new thread at watchingthewatchers.locals.com for our members only after party. So come and check us out over there. Also, robertgovea.com is the place to go if you want to download any of the PDFs, read any of the news, sign up for the daily newsletter, and check out some other cool stuff there, robertgovea.com. Don't forget to get a VPN provider, my friends, so your tubes are protected when you are connected at piavpn.com/Robert. Check it out, 4 months free when you sign up using that code. And before we wrap it up, shout out to our mods and our meme smiths modding down the fort for us. Zach, thank you for clipping away for us, my friend. Much appreciated. We've also got John Allen, Janek, Dog Digger, Donut Mind Me, Geo. We got Zulu, Ronnie Cole, Playing Hooky, Just Cause, K-Bean, and our friend Vienticus Prime. Shout out to our meme smiths, Geegum Geegum, Sleepy Dog Lee, and Nathan. N810, my friends, that is it for us on the day. Locals, we're going to see you in the new thread, so head on over there. My friends, that is it for us on the day here, and we will be coming back tomorrow to get into it all again, and I hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.